Let's roll, nerds.
I think I believe you're right. Like it's
Page 26.
As soon as I get done with arraignments, we'll start. And I don't know where's Blaze?
Judge, I think you just ran down it, but.
Okay,
Yeah.
go for it.
Judge, this is Nunley on page 26.
Good morning, Ms. Nunley. Ma'am, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 16th, 2025, in Harris County, Texas, an officer observed a vehicle driving over 30 miles per hour in a school zone by pacing the vehicle and officer's patrol car. The officer conducted a traffic stop. The defendant was the driver and the sole occupant and was ID'd by their Texas driver's license and AFIS fingerprints. The officer approached the vehicle and observed an odor of marijuana emitting from the vehicle. The officer discovered a backpack on the floorboard. The defendant stated the backpack belonged to her. The officer observed two small bags of a green leafy substance, one weighing 0.27 ounces and the other one weighing 0.075 ounces. The officer then located a small semi-automatic handgun in the backpack.
Nunley, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run her license, please? See if she has a valid license.
Yes.
Nunley.
Yes, you currently working on getting access to that. Very journalistic yourself.
Ms. Nunley, I'm going to find that there's sufficient probable cause to go forward with your case. While this case is open, I'm ordering you not to be in possession of a weapon. Do you understand? This, yes or no? This is your bond condition. If you violate these conditions, a warrant for your arrest will be issued. You will go into custody. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer, man? Deputy Miranda can give you an application. I'll have you fill it out and I'll take a look to see whether you qualify. I need to know everything about you and then we'll take a look. If you do, we'll provide you a lawyer today. For now, I'll have you go to Victoria, sign a reset, and then we'll have you take a seat in the first pew back there where you fill out the application, man. We file conditions, no weapons, please.
Counsel
Your Honor.
isn't hearing it. Do you want to skip over that one?
Who is it? Is that the only other arraignment?
Yes, the counsel is not.
I get it. Who is it?
Top of page 2.
I'm gonna see if I can call. That's Eddie. Okay. Yeah, we'll wait. Hi, Joe. You know? Yeah, of course.
It's the one from Monday that you emailed Chief Guys on Aiden Martinez. We're trying to get a response on the mitigation, so you emailed, whoever's on
Guys,
this?
have you heard anything on Martinez?
Aiden Martinez. We submitted a mitigation packet, waiting on a response from Chief Guys
Okay.
or PTI. Yep, there's nothing in the notes that she probably hasn't answered.
Yes.
Do you want me to stand down or do you want me to? I just.
Guys, so I guess as soon as he gets back, we'll start up.
So we have one that was set for arraignment yesterday. That was with the so we issued a warrant. He's here.
Okay, we can do that now. Alexis?
I have it. Is this,
Joe's? Yeah.
email address, that's not your.
Do you have anywhere else to go?
Yes, I can come back, Judge.
Please.
Okay.
Thanks.
For the case number?
Yeah.
The case number is 2560085. Pipkin, come on up.
2560085.
Yes. Yes, come on up.
Yeah, you had.
All right, stand right here in front.
Anybody's pocket.
Mr. Pipkin?
I know, sir.
So you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 14th, 2025, in Harris County, Texas, an officer on viewed a theft in progress at a Walgreens store. The complaining witness advised the officer that the defendant was leaving in a motor vehicle and that he grabbed several items of merchandise and passed all points of sale without paying for them. The complaining witness showed the officer a photo of the defendant as he was walking out of the store with 2 boxes. The officer followed the motor vehicle and observed it stop at a gas station. The officer observed the defendant as the driver of the motor vehicle and recognized him from the photo shown by the complaining witness. The officer observed a passenger of the vehicle and observed the merchandise from the store on the floorboard between her legs. The Air Slim headphones that were taken were in the backseat of the motor vehicle in plain view. The complaining witness stated she observed the defendant come into the store, grab the headphones, and walk out of the store, passing all points of sale. The complaining witness stated the female individual with the defendant grabbed a basket, filled it with several items, and walked out, passing all points of sale without any attempt to pay for the items.
Wait, so she did as well?
Yes, Your Honor.
Okay, so we have a co-defendant.
Yes, Your Honor, I believe that's the case.
I heard yesterday, or the day before, maybe Monday.
Okay.
Or she was good.
So the female individual with the defendant grabbed a basket, filled it with several items, and walked out, passing all points of sale without making any attempt to pay for the items. And the complaining witness stated that in total, the female defendant walked out with $388.78 worth of merchandise. And the defendant in this case walked out with $43.28 of merchandise for a total loss of $432.04.
Sir, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Walgreens. Do you understand? They have your picture there. So as soon as you walk in, you're going to have about 15 eyes looking all over you every single time you go back. Do you understand me? Do you get what I'm saying? Anytime you go there, you're going to have 15 cameras, eyes all over you. As it stands now, don't go back while this case is open. I don't want you to have contact with the complaining witness in this case. Do you understand? If I have to put you in jail, it's going to be at a high bond. No more PR bonds. You missed court yesterday. I will reinstate your bond today, but this is the last time.
I'm on side with it. I am on side with it.
Keep taking it. Don't pick up any new cases. Do you understand? I'm not asking for much, Mr. Pipkin. I'll provide you a lawyer today. Then we'll have you talk to them here momentarily, okay? Do not leave until you sign our bond conditions. Otherwise, I will issue a warrant. You understand? Can you file those conditions, please? All right, I'm gonna have you go, Deputy Miranda. We'll have you sign a reset and then we'll have you take your seat there. Okay. Damn, he needs some coffee.
That's it.
Where, is Ray back there?
They just walked out. Oh.
Are you gonna do an opening?
I think I'll wait it.
You're gonna wait it? Okay. So we'll bring jury in now and let's just get started, huh? You ready? Everybody ready? Okay, guys, we're going to start trial. If you need to talk, please go outside. If you need to use your phone, please go outside. No talking while we're on the record.
Judge, I'm gonna already interpret.
Oh, yeah.
She's here somewhere with all her stuff. Yeah. Yeah, it's right. Inventory. I don't know if they'll call him back.
All right, you ready? All right, bring the jury in, please. Thanks.
All right, for the jury.
Okay. Everyone, please be seated. Ladies and gentlemen of the jury, thank you so much for coming back. We didn't scare you off or you run away. We will try to be as efficient as possible because I know that your time is valuable. So with that, both sides will be afforded the opportunity to provide an opening. State. Floor is yours.
Morning, guys. Thank you all so much for coming in this morning. What we have here today is a simple case.
Your voice up.
Thank you. What we have here today is a simple case. On October 6, 2024, Officer Metter, where you're from, in a traffic stop. Makes traffic stop, goes to the gas station, there's some signs of intoxication, and then begins an investigation. After that investigation, he concludes or he believes that the defendant is intoxicated. He takes the defendant to the station. The test is performed there, showing the defendant is intoxicated. All of this I will show to you, and after that, I will ask you to find the defendant. All I ask is that you stay with me. At the end, I promise you, I will make your trial very simple. Thank you very much.
Okay. Thank you, sir. Ben, would you like to?
I think so, Judge.
Okay. What's yours?
State told you this case is very simple. Officer sees car, pulls it over, sees signs of intoxication, does test, boom, intoxicated, here we are, right? That's what the state wants you to believe. What the state didn't tell you is what you're going to hear about why the stop happened. You're not going to hear an exact speed. You're not going to hear anything from that officer that tells you any kind of traffic violation was committed. That's what you're not going to hear. You're also not going to hear what his blood alcohol was at the time he was driving. You're not going to hear that because they don't know that. You heard him. They stop him. They take him to the station. They do a test. The test is done well after the fact while he was driving. What the state will fail to show you and cannot show you is what his blood alcohol content was at the time he was driving. Not at the time he did his test, but at the time he was driving. That's an extremely important fact for you all to remember. You're not going to hear that. Not a single state witness is going to be able to give you that fact. And at the end of it all, after you hear all the evidence, after you see everything with your own eyes, we believe that the state will fail to meet its burden and that a not guilty verdict will be rendered. Thank you.
Let's take a break. Okay. All right, ladies and gentlemen of the jury, we're going to take a brief recess, give you time to handle any matters you may need to handle. We need to handle little business matters as well. I'll try to bring you back as quick as possible so we can continue, okay? Please,
All right,
you go
sure.
with Deputy Miranda. Okay, everybody, thank you for patiently waiting. I know you guys want to go. Let's go. Come on. Hi, Sina. What you got, bud?
Hello, Alzad, in your case, it's a reckless driving case,
Okay,
discussing it, she's been in trial, so yeah.
have we done PC yet?
No, it's very new case. Okay.
Let me, like,
Yeah.
Oh.
Second, I'll be right back.
Say
After option 262nd, I'll be right back.
Jason, what was the last name?
Alzad, A-L-Z-B.
I got it. Okay.
Z-A.
You do work with Betty, right? Okay. Mr. Albazin, come up.
He's got 4
Good morning, sir. You speak English? Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Thank you, Your Honor. On April 10th, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling at a high rate of speed, failed to signal a lane change, weaving in between cars, and following too closely behind other vehicles. The law enforcement officer matched the defendant's vehicle at approximately 100 miles per hour. A traffic stop was conducted, and the law enforcement officer made contact with the defendant, who stated he did not know he was going that fast.
Okay.
And if I could, Your Honor, just real quick, basically, we had an opportunity to look at the videos. My client has a radar chip in his car, we've shown it to the state. His car wasn't going over 90 miles an hour, and he clearly using his indicators. And on the video, the officer says that he doesn't know how fast he was going. His car has no radar, but he thinks it's 90 to 100 miles an hour.
I mean, you're going through video. This is just probable cause hearing. We could set it for something, but
There is no actual speed that he paced my client. So there is, just to let you know,
speeding in and out of traffic, falling too closely.
according to the officer, right?
So I'm gonna find probable cause for
That's
now.
fine.
We can always set it for, because I have to give them the
No,
opportunity.
absolutely, Your Honor,
No.
absolutely. I
So,
think the chief, once he's, done with this trial, he's already told me it's gonna be either a class dismissal or straight up dismissal.
Mr. Albazin, I'm going to find probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive in this manner again. If I find that you drive at speeds of 90 to 100 miles an hour, doing reckless driving, weaving, I'm speeding, I'm going to revoke your bond and put you in jail. Just, we have enough crashes on the road. Don't add to it. You know what I mean? No reckless driving, racing, street takeovers, donuts, nothing of this matter. Got a great lawyer. He's going to help you out. Stay in touch with him. We'll give you guys time to work on the case. I'm going to have bond conditions created, so you promise us that you're not going to drive like this. If I find that you do, I will revoke your bond and put you in jail. Do you understand?
Yes.
Okay, so we'll have you sign a reset. Just have him take a seat. We'll get bond condition created, and then once you sign it, at that point, you can leave. Leave. Can you file that, guys, please?
Yes, Your Honor, what are the conditions?
So no racing, reckless driving, street takeovers, donuts.
Yes, Your Honor.
Okay, Mr. Beadle. So I signed the jail release conditions. We'll do a PR bond now, so that way she's good to go. No, I don't think so. No, I think you're good to go. You just make sure that, don't send her down until she sends a PR bond, and then, yeah, she's here. We got her.
She's gonna be the chair on this lunch?
Yes. So, Ms. Roxanne, do you mind giving Ms. Lynch a PR bond, please? Okay, and then as soon as it's processed, we'll have her sign it, and then she's good to go.
She's gonna sign it, or we're gonna bring her out?
Well, yeah, we'll have to bring her out so she can sign it. That's why we put her on, so that she can sign. Yeah. Okay, hi.
I have Ms. Deia on docket.
Okay,
She was accepted into the PTAC program, but we're trying to knock out some kinks, with a no driving affidavit. I was wondering if we could amend her bond conditions to give her portable and have the county pay for it before she goes into the program.
can't pay for it when she's in the program.
Before
If
then,
she's on bond, I can, but once she signs into the contract and gets into the program, I cannot pay for it any longer. I pay for virtually everything for as long as I can, but once they're in it, or on a probation or on a PTI, I no longer have the authority to pay for it. If I could, I would, but I just can't. So she'll have to sign a no driving affidavit, and you can get one from Shatoria. Then once she gets the portable device, at that point, we can take off any guardian interlocks or anything else that she has. Yeah? And then, what about the DA fee? Has she paid it yet?
So we haven't yet. So should we just put out her form? We got accepted on Monday. So if we just got her form, she filled out her form and then
Which form for which one?
the client intake information form.
Got it.
Yeah, so we just got that on Monday. She filled that out today. And then the no driving, she emailed me that her driver's license was ineligible on Monday as well. And so
Okay.
put in a no driving affidavit.
Okay, so how long do you want? Okay, done. Yeah, okay.
Thank you.
Yes, ma'am. Hi, Joe.
Judge, coming back on Mr. Martinez,
Nice.
sir,
Tell me something nice.
no response yet, Judge. Like I said, I have some from January that I still haven't received responses, so March. Can we get like a week reset, Judge? Okay, right, thank you. Parents, wait. Okay, thank you.
Unless there's approval or denial at that point. Yes, sir. Okay, thanks, Joe. Shreya. Hi, good morning.
Justin Harris on the fugitive docket.
Justin Harris?
I know. I kind of laughed at him.
I'm just kidding. I'm just kidding.
It's funny, 'cause I just seen him yesterday. Justin Harris is on the fugitive docket. He waived at magistrate court and has vehemently changed his mind.
Should we? Your laugh? Do you want me to bring him out?
So Judge, if you want to bring him out and admonish him, Philadelphia, from what I hear, does want him. Is that right, Amy?
Yes, we're on their way here to get him today, but if he's withdrawing his waiver, of course they can. If he intends to withdraw his waiver today, they obviously can't pick him up today, so.
If they're gonna get him, they're gonna, hey, Deputy, you mind bringing out Justin Harris, please?
And then while he's coming out, do you want me to reset the Dustin Eli hearing?
Have they done anything upstairs? It's on docket today?
No, they haven't. So I was gonna talk to you about that. If he takes TDC up there, would you consider?
If he takes TDC, there's nothing I can do.
I agree. And that's, I mean, and I hate to say that because I don't know what they're doing, but if we could
Obviously, if he
reset it, I
takes-
think it's an option.
No. If
Okay.
it takes TDC time, I'm putting
Okay,
in effect.
and I hate to say that because I don't know what'll happen in May,
no-
but I think it's could be worked out. Yes, Judge. Your other option was to put him into SATA.
No. My feeling is that he's probably gonna end probation, right?
No.
Really? Have they not offered probation upstairs?
They might, but considering the nature of it, if they do, they're gonna require SATA, right?
I mean,
Right. And that's the end goal is, I don't think he wants that.
he's willing to go to TDC instead of going to treatment, for real?
Yes, I know.
Well, I mean,
I've talked to him. I know, and I'm gonna set up another meeting with him to go over things, but
be the horse to water.
you know, there's only so much I can
I know.
admonish.
Yeah, so
They just.
that case is set for May 12th,
So
I
if
guess.
if I can just get like a day or two after that.
Absolutely. Good morning, Mr. Harris. So you're wanted out of another state. You already waived, and your lawyers tell me now that you would like me to set you a bond so that you can go out and go turn yourself in.
Oh, no bond. I just wanted him admonished on the extradition timeline.
Okay, so you've waived. What happens is we give the demanding jurisdiction, which is who?
Philadelphia County, Pennsylvania.
Okay, what's he wanted for?
Murder, endangering welfare, and
Okay, yeah. So you're wanted for murder and what else?
endangering welfare. And then they're charged that's REAP.
Well, they,
Rape?
It's they spelled it REAP.
ain't no damn rape. I ain't raped nobody.
I don't know exactly what that one is, but for sure.
So understand that we just get the teletype that tells us what it is. I have no idea. Here, we don't fight the case. We only try to establish identity. If you are the person that is wanted from the other jurisdiction, I don't know. The good news is though, is that you've waived and they're coming to get you today. so we could really get you on the way back to Philadelphia today.
No, I said I'd rather put the 30 days in. Didn't I tell you that?
You did, but I'm just admonishing you, it's not just 30 days,
So
30
what
days.
happens now is,
Yeah, 30
I just wanna make
days.
sure you understand that.
so what happens now is if you refuse, which is your right, they'll get a governor's warrant, but that'll take up to 90 days to get,
I'm
you
fine
know?
with that.
And then the pickup is 30 days after that, just to make
Okay,
sure we're good
I'm
with
fine with
timelines.
that. I'm fine with that, because I'm
Right,
trying
so-
to get everything in order back to there. I'm not about to ride, rush, be blind, go back to Philadelphia, and then I don't know what's going on inside my county, like, as far as being held inside, like, it just.
You want it from other counties as well?
I have no knowledge of that at this time, Your Honor. I would have to run a criminal history check if I did one of the processes.
So I guess you just want them to get a governor's warrant, then I'm assuming
Yeah.
then. Okay, so if you just want to go ahead and, you know,
I'm gonna find them.
And then Judge, the waiver withdrawal should be in your queue.
yes, it's right. Okay, I'll sign it and then, all right. So I guess let's set it for 45 days? What do you think?
I had him set out for 30 days.
Okay, not a problem.
So it's gonna be May 23rd.
Okay, so the problem is you have to understand also is that when someone is charged with a crime that has a potential life sentence, I can't give you a bond even if I wanted to. Just that's the way the statute reads. So, okay? All right. Good luck to you, Ms. Harris.
Thank you.
Thanks, Judge.
Thanks. Hi. Mr. Davidson, did you? Hi, how are you? Pretty good.
I'm just here to take care of business. I don't have anything.
You know nothing? Okay.
Nothing for the court at the moment.
Greg? Nothing. Hey, don't go far. We're gonna start up soon.
We need to approach before we do.
Okay,
Before we bring Trey back out, let's have a few matters I want to think of.
okay. I think that Blaze went up to the felony court regardless, so
All right.
Blaze went up to one of the felony courts, so I don't know when he's gonna come back.
Does we have an arraignment, are you ready?
Yeah,
All right, page 5, bias, come on up.
hey, where's the other prosecutor? Where's John?
Pipkin,
Where's John, the other prosecutor? Do you know? Hey, Cole, can I borrow you real quick so we can do PC real quick?
Yes, Your Honor, of course. My apologies.
This is Mr. Bias. B.A.
Oh, Ms. Pipkin?
All right, Mr. Bias, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Can you, I get the name one more time, please?
Let me give you a cause number.
Yes,
Tell me when you're ready. 256
256
0257.
2257.
All right, thank you, Your Honor. On April 15th, 2025, in Harris County, Texas, an officer observed a motor vehicle traveling on the Gulf Freeway. The officer visually estimated the motor vehicle speed to be between 115 and 120 miles per hour in a 60-mile-per-hour zone. The officer attempted to catch up to the vehicle and observed approximately 15 to 20 lane changes from across all 4 lanes of traffic around other cars that were obeying traffic laws. The officer had to travel at speeds in excess of 120 miles per hour to catch up to the defendant's motor vehicle. Officer caught up to the motor vehicle and paced it at 115 miles per hour for approximately 1/4 mile. A traffic stop was conducted and the defendant stated, "I effed up."
Run his license, please.
Yes, Your Honor.
Mr. Bias, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to drive in this manner anymore. If I find that you're a danger to my public, it's not going to go well for you. Do you understand? I will revoke your bond, put you in jail, no more PR bonds.
Yes, sir.
The license is open.
You are not allowed to drive unless you have valid Texas driver license and liability insurance in your name, and that is a condition of your bond. If I find that you do, or that you drive without, likewise, you will go to jail. No more PR bonds.
That's all.
We are going to reset your case to give you time to hire a lawyer. I'm going to have the state create bond conditions that you're not to drive in a reckless manner. You're not to participate in a racing street takeover, donuts, anything of this nature. I will do everything in my power to protect my city at all costs, Mr. Vice, and I want you to understand that. And if I find any more of this, it's not going to go well for you. Do you understand?
Yes, sir.
Do you mind filing those conditions, Cole?
Yes, sir.
For now, I'm going to have you sign a reset with Victoria. We will have you take a seat while we get your bond conditions. Once you have signed them, then you'll be free to go. Please. Yeah. Hi.
I had a quick question regarding off docket.
Okay.
252-1794. The name is Crystal Gonzalez.
Okay.
She's scheduled, her case is old, and she's required to appear tomorrow. You said she would have to appear if everything isn't done for PTI. We have her contract back. I talked to Ms. Gomez, she's the PTI coordinator. She said that the only thing she needed was the contract and proof of the device. Well, we have her contract back, and she also attempted to get the portable device, but they don't have it coming in until the 28th, which is Monday. And I have a copy of her contract for the portable device. Will she still need to be present on tomorrow?
Have proof that the device is coming in on the 28th?
Yes, sir.
Okay, no, I trust you. As long as you have it, then we'll set for the 28th.
Okay.
Okay, and she has to have everything done by then.
Yes, sir.
Okay, no more waived appearances.
Yes, sir.
Okay.
Can you answer?
Yes, ma'am. Hi, Sarah. You ready?
I'm not approaching.
No, oh, no. Come on in. That's okay. Hi.
We have Edelbert Rosa on docket, ROS.
Okay.
We still do not have a response on the mitigation packet. We emailed them this morning, and there's an email saying it might still be under review. We submitted it 4/7.
Okay, so we'll set you
Franco
off.
comments.
Set you off 1 week for them to get you verified.
Will my client need to appear, or can he be waived?
If it's not back, then no, but if it's back, he's got to get everything done. No more waived. It's 230 days. No more waived appearance. Okay. Okay, hi. Come on up. Yes, sir.
This is an off docket case, Judge.
Okay, what's your cause number?
255-8479.
On Billings.
Yes, Judge.
Okay,
He was present here in the courtroom. Police made contact, did not arrest him until the blood test came back. The warrants have now been issued, so we're here to address that.
I'm bringing him up.
Yes.
You get the cause number?
Yes, sir.
Go ahead. Hey, this is a new case.
Sorry.
4/17/26.
This is a new case. You are Mr. Billings?
Yes, Your Honor.
Mr. Billings, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine because of the high level of alcohol. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay, cool.
Thank you very much. It's not loading for me, just 1 second. I've already computer, it's on.
Roxanne, did you get this cost number? I need to give it to you. It's a new case. 255 8479.
Thank you, Judge.
Sure, let's go.
On December 7th, 2024, in Harris County, Texas, officers responded to a motor vehicle accident. The officer arrived and observed two vehicles that had been damaged and rendered inoperable. The defendant was ID'd by his Texas driver's license and ID'd to be the sole occupant and driver of the motor vehicle. The officer relocated the scene to a nearby parking lot to safely conduct the investigation. The officer determined the defendant was at fault for the accident after speaking with all the parties involved and reviewing information collected at the scene. The defendant stated he had left a bar called Sugar Room. The defendant stated he drank 2 beers at the bar. The officer noted that initially the defendant was not even aware that he had been in an accident. The officer observed the defendant to be lethargic and confused. The officer observed the defendant to have slurred speech, glossy eyes, and trouble maintaining their balance. The officer had to ask questions multiple times to obtain simple information from the defendant. The officer did not notice alcohol emitting from the defendant despite defendant's admission to drinking and defendant's apparent physical and mental impairment. The officer suspected the apparent impairment of the defendant could have been caused by some kind of narcotic. The defendant refused to perform standard field sobriety tests. The DIC was read. The defendant agreed to provide a blood specimen, and the lab results came back to a 0.17.
Okay. Any prior DWIs? And does he have
the first?
and valid license?
Judge, his license was recently suspended ALR. He will not be driving. He has a 90-day suspension.
Okay. I want you to understand something, Mr. Billing. I take this extremely serious. I don't care what you have to do in your life. If you do not have a valid license and liability insurance, you are not allowed to drive, and that is a condition of your bond. You will be signing an affidavit with me today promising me you're not going to drive. I don't care if there's a burning building and you have to say 50 kids. Do not drive. Do you understand?
Yes, sir.
Nothing you can say justifies getting into a car and driving. I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, I will revoke your bond, put you in jail. No more PR bonds. You have a lawyer. Because you do, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him and he'll tell you if and when you have to come back to court. If you get called upon to go take a test and you fail to go, a warrant will be issued for your arrest. Do you understand?
Yes, sir.
Okay. But now I'm going to have you come up here, swear to us that you're not going to drive. I will get you to Victoria where you'll sign a reset. After that, you'll get to Roxanne where you will get your bond conditions and then you're free to go.
Thank you, Judge.
Thanks. Yes. Okay, counsel.
Morning, Judge. How are you, sir?
Howdy. Been a while.
Yes, sir. I'm doing well. I'm here on Matthew Owen this morning. I'm here for Mr. Pulowski. He's across the hall doing a plea. It's been my understanding that he has been accepted into PTI. He's done his TRAS. We've gotten the TRAS back. We're just waiting on the contract from the DA's office.
Cole, what say you on Mr. Owen?
I do have a note here. We have the TRAS saved, and I have a note from today at 9:02 a.m. that it says DWI PTI insurance expires 9/18/25. I'm not sure if that's the valid insurance that he had to submit or something like that.
Believe it would be.
Okay, and then that's the latest I have on that, so I guess we haven't gotten a contract.
You're not going to get it, I guess, until they give you get insurance.
That's what it's sounding like.
So we'll set you off for a week. Okay?
Yes, sir.
It's getting old. It's 190, so no more waived appearances. If you get everything done, then I'll waive it, but if not, he's got to be here. Okay?
Absolutely. Yes, sir. Thank you.
Thanks, man.
Is it John or is it?
Oh, I don't know. Wait a second. Bond? Is he on bond? Did he make a bond?
No, Judge, we asked for a PR bond. I thought you said you granted him a PR bond.
No, we haven't. I assumed that, no, I haven't given PR bond.
Yes, we're asking for the PR bond. He was not arrested.
It's a two.
Just showed up.
Okay, come up, Mr. Billing. I didn't realize that. Thank you for saying something. All right, Mr. Billings, I'm going to give you a PR bond today. There's a warrant for your arrest, so I'll give you a PR bond today, but I want you to understand, I don't continue to give PR bonds after PR bonds, especially if you're a danger to my city. I'm gonna give you one now, but there won't be multiple ones. You understand? Okay, all right, you're done. Thanks.
All right, so just have a seat and please follow the motion.
Hey, Jay, what's up, man?
I wanted to reapproach on Justin Harris. I know I just missed it by a hair. I was upstairs in another hearing and I wish I knew about
No,
it.
I've never refused or denied a waiver withdrawal.
Because it's in your power to do so, and obviously you haven't seen.
And are they still coming here today?
They're here right now.
Then I'm not gonna grant this waiver withdrawal. Let them know. They're here
I
from,
can't let him know. Well, okay, I'd love to let him know.
they sent them down already?
Is there any reversal?
Is there a way to communicate to where he's going?
We're going back to jail, so he's already in time for headed to jail, so that they know to get some back.
Okay, so let's do this. I'll reach out to my court manager to try to tell admin to let him know.
It's like something, and I'll let his family members know, but I don't mind even going to the jail, but I think that I won't do it.
No, I'll call my admin right now.
Sylvia?
She can get it. Yeah, she's
She's
an
magic.
adult.
She's
So-
magic. Do you want me to wait, see if he gets brought up, or y'all can?
No,
just
no, no,
pass
no,
along?
we're not gonna get him back up.
Just pass the
They're
message.
saying he's in transit back and then which is good because that way they can get him to
Right, and
Pennsylvania.
Right,
Let me
and
just
it's,
step out.
sure, it's e-filed, so I don't know what you do electronically, but,
I can unsign it.
okay,
That's not a problem.
Okay, thanks.
Reach out.
thank you, Judge.
Stacy. Hi.
I have Mr. Deia, the custody case.
Okay.
And Your Honor, he has two DWIs. I was speaking to the state regarding an offer for a time served on one and dismissal on the other.
Okay.
We were just wondering if you would accept that offer.
Yeah, I mean, I'd be hard pressed to do a time served, but,
He's been in
yes.
custody for 21 days, has an ICE for previous deportation. No videos on one of the cases that I'm requesting get dismissed. They're not gonna get it.
Okay, yeah. We do like, I don't know. So he has how much?
I believe
25 days.
So do 60 credit for 25 and on whichever one, and then,
on the one with the
Well, yeah, I
videos.
think we were at 75, just.
oh, yeah, whatever you want. Yeah.
That works.
Yeah, yeah. Okay.
All right, Judge.
And then are you guys ready to?
We're working on that redaction issue right now. So,
He said he wanted to approach on something too.
yeah, this was, yeah, completely. Yeah.
I don't know if you want this on the record, but I've thought about it. I don't think I'll need Metter again. Because he didn't say that any consistent statements were a major player, so.
Yeah,
That's
no,
really I was gonna
that's
focus
something.
on.
No, so let's just let him know. So, I mean, he felt awful. Let's just get him out of here,
Yeah, and that, he's got to work tonight too, so,
Gosh.
yeah, so I'd rather just get him out of here.
That's good.
Do we want to put that on the record?
Okay, quiet, we're going on the record. Please do not say anything. All right, we are back on the record in the trial case. And after speaking to both state and defense, both of you guys have come to the agreement that you are ready to release Deputy Metter, not subject to recall anymore.
Correct, Your Honor.
That's correct, Your Honor.
Okay, all right, so we'll let him go.
Thank you, Your Honor.
I guess we'll start here momentarily.
Thank you, Your Honor.
Thanks.
Page 4.
Hey, hi, Maverick, come on up. How are you?
Good, you?
Good job,
Don't know what to do about Mr. Burnett, or Mr. Bennett. I know that you said he had a prescription,
He does.
right? But, that prescription was from, what, 6 months ago or something?
I think he has he has numerous valid prescriptions. Do you not? Can I bring him up here until I can talk to him?
Yeah, but
He does.
otherwise I don't want him to use, I mean,
I get that. That's where, and as a lawyer, it's hard for me to sit here and tell him like, hey, don't listen to, if the doctor's, again, I get the look and feel for these types of prescription, just give them, there's tons of pill mills in the city. I get that stance, but then it's also hard for me to say as a lawyer, well, how do I say,
but this guy needs it and this guy doesn't when I'm not a doctor. And so it's hard for me to tell him, hey, don't do what the doctor says when
When did we do our first?
I feel like I've been here once a week, every week for the last 3 weeks on him.
That's what
I mean, it's fine. Yeah, I get it.
No, I
I
mean,
get
that's why
it.
they're so
And
difficult.
it's not,
I want to, what
I'm not
would-
upset by that or anything, but.
Here's what I want to know. I want to know when it's going to stop. He's got a prescription. If I remember, it was for 90, right?
This probably sounds right. Yes, Your Honor.
So I want to know when it's going to stop because I'm not going to let it continue for the next 6 months. You've got 90. You're not going to sit here and tell me that 90 is going to last you for the next 6 months and that you're going to continue to use. It's not going to happen. Come up, Mr. Bennett. And what's the purpose for? Is it for an injury? Is it for?
I think it's I could have sworn he was in a motor vehicle accident, but what are you on pain medicine for injury or what?
I was in a wreck, but I haven't been using.
You're still testing positive for it?
When the last time I tested positive?
Last week.
I wasn't positive for it.
No.
Or
tested positive?
we were here on, was it Thursday or Wednesday of last week?
Last week, I did not test positive.
This is Mr. Bennett. When was his last UA? Please. If you're clean, I'm jumping up and down. Really?
Of the 17th, you told me the same thing, and I went and did my drug test, and I ain't have it in my system.
Let's see. I don't know. The last one I
I got
showed.
an email that he did, so that's why I assumed that he did, but I don't know.
And that's what I got too.
Last time I did a drug test, it wasn't in my system. Where they shake the bottle and show you right in your face.
His last drug test was on the 22nd, so it was yesterday.
And
I didn't.
Results?
They were presumptive positive for THC.
That's it?
That's it.
Okay.
Wonderful. That's great. I'm proud of you. Great job. Great. I'm going to test you like crazy still. Don't use. Please. I'm going to let you go for the time being for the weed. But, after about 50 days, if you're still testing positive, that means you're continuing to use. Just don't. All right?
Sir.
Okay, we're good. I'll continue supervision. Okay, great. All right. Guys, you ready?
Judge, I'll just have a motion real quick, but other than that. That's okay. Yeah. So.
You're going to do it now?
Well, I'm fine.
Oh. Please.
Yes, I got the read. I got.
You're here? You're here. Guys, we are going on the record. Please do not talk. If you need to talk, please go outside. Okay, so we're back on the record in the trial case. And before I ask the state to call its next witness, Ray, did you have something that you wanted to do?
I do, Your Honor, and just wanted to ask the court, I would file an oral motion to suppress any evidence obtained from the traffic stop. I don't believe there was probable cause for the traffic stop. Officer Matter indicated that he could not tell how fast he was going, that it was less than a quarter of a mile before to the next light where my client was stopped. It took over a minute for them to get there. Therefore, whatever speed Officer Matter perceived is inaccurate. He even indicated so himself. Also, Judge, at the same time, Officer Matter said that if not for his perceived speeding, he would never run by the client's license plate. And I don't believe with him not running the license plate, he even indicated that had he not perceived him to be speeding, he would have never ran his plate and therefore would have never found out about the expired registration. And on top of that, the officer also testified that the expired registration in and of itself is not indicative of driving while intoxicated. I don't believe there was probable cause to pull him over based on the inability of the officer to say how fast he was going. And I don't believe that without that reasoning, he would never run his plate. If he would never run his plate, and found out the expired registration, he would never got into the field sobriety test and we would not be here. So I'd ask for all evidence to be suppressed based on the fact that the officer did not have probable cause to even run his plate or stop him to begin with.
Okay, response?
Your Honor, the state would offer that there are several arguments to be made here. The first of which is that the officer's suspicion was initially triggered based off of what he believed to be speed. He then follows that up with pasting, a method that is commonly used and applied by law enforcement. And he also verified that his speedometer was calibrated that day. Because of that, he was able to pace the defendant at a speed that, even if it was not the speed of 64 miles an hour that the officer testified to, he knew that it was at least above the posted speed limit, which on its face is enough for the officer to initiate the traffic stop. However, the officer did not stop there, he went further. And even if that part of pacing is not accepted by Your Honor, the next part that the state would argue would be that the officer's initial suspicion was triggered. He continued to have suspicion of the vehicle. And then once he got up to the vehicle, he ran the registration. As he testified, he can do on any vehicle, as is commonly accepted. That once he found that the registration was expired, he then initiated a traffic stop at the next possible moment to do so, which, because of that expired registration, on his face is sufficient sufficient for the officer to initiate the traffic stop.
Okay, I get it. I'm going to deny your motion. I mean, I think that there's enough to go on. You know, officers, the training experience, it's a 30-mile-an-hour road. They know when it's faster than that, and then they can run the license plate for, I'm going to deny the motion. Sorry,
Your Honor.
Okay. State, you ready to call your next witness?
Yes, Your Honor.
Okay. Guys, we have a jury coming in. Or hold on a second. Hold on. Mr. Bias, come up. We'll have you sign so we can get you out of here. Is there anyone else that we need to get out? Okay. Lawyers, anything else that anyone wants to talk about real quick? No? Bueller? Okay, let's go.
I just think at lunch, Your Honor, we're gonna make sure all of our redactions were good and we're gonna go to that lunch break.
Yeah, we'll do that at lunch. Let's at least get through one more witness before lunch.
Yes, Your Honor.
Can you do the jury first?
You ready?
All right.
Let's go. Come on, get him. Bring it. Okay, ladies and gentlemen of the jury, we're going to continue now with the state's next witness. Everybody please be seated. Who's your next witness, state?
The state calls Officer Nicholas Ruiz Flaguen to stand, Your Honor.
If you mind, Deputy Miranda.
State pass the witness, Your Honor.
Okay.
Can I proceed, Your Honor?
Please.
Okay, Mr. Varner. You indicated that part of your process is to make sure that the defendant is in your view for at least 15 minutes before administering the test. Is that correct?
Yes.
And it has to be 15 minutes, right?
Yes.
And what is the reasoning behind that?
To make sure that the AC level is accurate at that time.
And that you're supposed to do that on every single breath test, correct?
Yes.
You didn't do that on this case, correct?
No. I'm sorry. Repeat the question again.
I said you didn't do the 15-minute observation period on this case, correct?
No, that's not correct.
So you did do 15 minutes.
Yes.
And you're absolutely positive about that.
Yes.
Just as positive as you are about the breath test and that the toxicologies are working accurately, correct?
Yes.
No doubt in your mind whatsoever.
No doubt.
May I approach, Your Honor?
Please.
And we'll probably need a break, Judge. I've got some videos I need to show him.
Okay, can you take the jury out, please? Jurors, we'll take a 5-minute break. I'll bring you back in and we'll continue. Okay.
All right, for the jury.
Please proceed. Ray, what you got? Have you seen this place? Do you know?
It's evidence. That's not, no, it's not evidence, but it's an our case.
Okay, got it.
Sorry.
Hey, guys, is there anyone else that needs anything? You have one plea. You do? You have a plea? Kill two birds with one stone. Hey, while you're discussing, can we do a plea?
Yeah, I'll take your option.
Okay, bring him. Tony, do you mind helping us out with this plea real quick?
Let me get.
You have the paperwork? Or you would sign? Sure.
Yeah. Yeah.
All right, you are Mr. Deia Nunees.
Yes.
You were charged with 2 counts of driving while intoxicated. You have worked out an agreement where they're going to dismiss one of them. You're pleading to the other one. It's 75 days in jail with credit for the 25 days that you have done. Is this how you understand the agreement?
Es el mismo acuerdo. I'm sorry, Judge.
Is this how you understand the agreement?
Entiende que era el acuerdo. Yes.
Giving up the right
Está
to a trial,
renunciando su derecho a un
right to
juicio.
compel witnesses to testify on your
Su
behalf,
derecho a tener
confront and
testigos que se
cross-examine
te
teachers.
interrogar.
If you're not a
Esos
citizen, there are
testigos,
possible
si no es
immigration
ciudadano,
consequences.
hay
You can be
posibles
deported,
consecuencias migratorias.
excluded from the country,
Puede ser
denied
deportado,
naturalization. You give up
excluido del
the right
país,
to
de
appeal.
naturalización,
Once you plead
vence tu
guilty,
derecho a
this
apelar.
will go on your record.
Cuando esto
It's going to
termine,
be there
te vas a
forever.
expediente y permanecerá ahí por siempre.
So
Yes.
from now on,
De ahora en
if
adelante.
you ever get pulled over, an officer is going to see all these DWIs. And if you smell like alcohol or dope, it's probably not going to go well for you.
Ahí bien.
Every day, someone dies from a DWI in our nation, in our state, in our county. Don't kill anyone.
Mate a nadie.
No mates a una persona. Because of these DWIs that are with you now, I'm telling you, anytime you get pulled over, you have a funky smell. It's probably not going to go well. So if you're going to drink, if you're going to have 32 shots of tequila, 52 beers, don't get into a car. Do you understand?
Entiende. Yes.
I'm going to suspend your
Voy a
license for 1 year.
suspender su licencia por un año.
Okay. Do not drive until you get a license. The other thing I'm going to tell you is I don't know what your immigration status is, but if you're not in this country and you continue to come back without permission and you get caught by the feds, it could be a 5-year federal sentence on an illegal reentry. So be careful. If you want to do things, do it the right way.
Hágalo de manera correcta.
How do you plead to the offense? Guilty or not guilty?
Culpable o no culpable.
Culpable.
Guilty.
Find you guilty. I'm going to
Lo
sentence you.
culpable lo
Good
sentencia.
luck to you, sir.
Buena suerte, señor.
Okay, thank you.
Thank you, Your Honor. May I be excused?
Okay. Family, you ready? Ready?
I think the state wanted to address an issue with you regarding
Okay.
the videos, Judge.
Come talk to me. What's the word?
So, you want yes. You want to just informally move on?
Yeah, we could do informal first and then.
Okay, sure. So we're not on the record now?
No, not right now.
Okay, talk to me.
So what I was showing him is the video from the in-talks room in JPC, where it shows that he comes in and then 6 minutes later is when he actually does the test. What they're informing me is that the observation period began outside, but there's videos from the outside, which we don't have, so there's no way of us to confirm the 15-minute observation period. I'm asking for these to come in just so I can make that argument. I think the state's going to object to it as to the weight of the evidence. So
I'm just objecting to him having admitting this evidence.
I thought you said.
No objection to the videos coming in. No. If you want to do that, that's fine. I'll just, I'll go back.
Yeah, I'm gonna let it in regardless. I was gonna let it in.
I thought you said something about the weight of the evidence.
No. I was saying if you are objecting to like some kind of breath test, saying, well, the breath test isn't good because we don't have this video, I would just say it's not a, it's
Is
not.
there a
admissibility
time
question,
that
it's a weight.
delineates when he was actually arrived at the station?
No,
Come on, there has to be.
it's not.
There always is. They document damn near
The
everything.
offense report,
The offense report does, but he can't testify to the offense report.
no.
Yeah, that's. Sarah, do you need anything before we start off? No? Okay. So let's go. Let's, you ready? No, I want to see how far we can get, you know. Do you have any witnesses?
I don't.
Yeah, just literally, just have them eat, deliberate and eat. You ready?
What's the food?
Pizza.
That's probably cool.
I'm sure that they would run get it and. So you're starting right now, right?
Yeah.
You haven't done anything yet so far, am I right?
No.
Josh,
It's just a USB drive.
oh, I remember. I mean,
You're good.
leave your cell phone for it and it shows.
All right, for the jury.
Okay, please be seated. Ray, you may continue. Anything further, state?
Judge Mood, Coach.
Sure. State, do you have any further witnesses?
No, you have.
Okay, so you rest.
Yes or no?
Okay.
I'll have a motion, Judge.
Okay, so hold on. Can you take the jury out for 1 second? But don't take them far. Yeah, but just don't take them far.
All right, for the jury.
Okay, please be seated.
You've gotten right outside the door, there's gonna be drugs.
Sure, of course. For what it's worth, I don't think they can hear anything, but absolutely. Yeah.
Rather
Of
safe,
course.
sorry.
Absolutely.
So Judge, I'd be asking for a motion to directed verdict. I believe this state has failed to meet its burden beyond a reasonable doubt. First and foremost, they never established whether or not he was operating a motor vehicle. They identified the type of vehicle, but they didn't ask any witnesses if it was a motor vehicle, and that was never established. That's the first part. Second part, I don't believe they've established intoxication beyond a reasonable doubt. They never asked any of their witnesses if the person had lost the mental or physical faculties. All they did was go through the field sobriety tests and indicate what the results of the field sobriety tests were. But none of the witnesses indicated whether or not they had lost their mental or physical faculties. And on top of that, finally, Judge, with this witness, the breath test, he was able to establish that the breath test was done at the time or that was his blood alcohol concentration at the time of the test, not at the time of driving. Without any additional information, there's no indication what his blood alcohol was at the time of driving. So therefore, I don't believe they've established their burden as one, as to a motor vehicle. Two, which the complaint or the information says, operated a motor vehicle in a public place in Harris County, Texas. And then also as far as the intoxicated portion, like I said, no testimony as to loss of mental or physical faculties, and no indication that it was at a 0.08 or higher at the time he was driving. So I'd ask for a directed verdict at this time as the state has failed to meet its burden.
Your Honor, I'll try and go in order here. The facts clearly show that it was a motor vehicle, maybe simply because I didn't ask for a conclusion statement from the witness, but demonstrated that the defendant was in fact driving a motor vehicle by the facts that were given. The officer testified that the defendant was the driver of the vehicle. There was no one else in the vehicle, that he witnessed the vehicle the entire time from when he first witnessed the vehicle.
Yeah, stop. I disagree. I think that there's enough to go forward. You know, I do. I think they testified to it that, you know, we asked them the ultimate question. So, I mean, I think that there's enough to go forward.
But my understanding, Judge, is that the state has to meet each and every one of their elements beyond a reasonable doubt. One of the elements is a motor vehicle, and that was not established beyond a reasonable doubt at all.
He testified that he pulled him over.
Correct, Judge, but it could have been a go-kart, it could have been anything.
He's on video in a car.
Your Honor, the state still has
Okay,
to
no,
establish.
I disagree. I think that they've met it. Let's go from,
We take a plea, Your Honor.
no, I've got a jury coming in. Give me 5 minutes.
All right, so the jury.
Now, and then we'll do the charges. All right, everybody, please be seated. Okay, so you have rested. Defense, do you have any witnesses?
We do not have any witnesses, Your Honor.
Okay, so defense rests. Okay, so now we have some business matters to attend to prior to closing. So what I'm gonna do is I'm gonna feed you guys now. I know that you're probably pretty hungry, so I have lunch for you now. We're gonna try to, like I said, be as efficient as possible. So eat. I'm gonna bring you back probably 15 minutes, so we can just get started and keep moving, okay? We're close though, all right? Please.
All right, so the jury.
Okay, be seated. Okay, all right, Michael, you ready? Okay, they're reading?
Judge Mayor,
No.
can you hear something?
Oh, we're printing a charge for you. Is that okay?
I want to ask for a specific instruction. I want to put the case law for that instruction.
Which,
3823.
I'll give it to you. Yeah, don't worry. I'm gonna give it to you. Just, do you have one for me?
A case law?
Let me hold on.
Or- Oh, no.
Ramona.
How do you do it?
Thank you so very much for being patient. I really appreciate it.
Yeah. Yes, sir.
Thank you for coming back here. Okay, so Ms. Davis, I guess you've had all the discussions, decisions, you know what you're doing. We've given you sufficient amount of time. You've now accepting this agreement where they charge you with assault. You are pleading guilty to this offense. It's going to go on your record. It will be there for the rest of your life. You can never take it off. Like I said, from now on, you pick up any cases, you're likely to be looking at a minimum of 90 days in jail. You understand? You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, there's no turning back. Is this what you want to do?
Yes, sir.
How do you plead to the offense of assault?
We'll see, sir.
I'm going to find you guilty. I'm going to sentence you to 3 days in jail, give you credit for the 1 day that you've done. I'm going to roll your report costs so you won't owe anything, and good luck to you.
Thank you.
Thank you, Mike. Okay,
Thank you.
yes, ma'am. Our system is down. That enables us to sign stuff, and it's been down for like 45 minutes. So that's why I've not been able to sign your PR bond. I still can't sign it. That's what I'm waiting on.
Yes, Judge.
Yeah, Vic, Deeds is completely down. I can't sign anything.
Yes, Judge. It's been down for a minute. They've already submitted a ticket. So we're just waiting.
Do another damn ticket, man.
We'll do.
I just found that this was.
Issue a warrant.
I'll do one on you.
They already got Justin Harris.
Judge, you have a very important phone call.
Hello? Who? Okay, well, you want to reach out to him? I can let him do it through Zoom. But, ma'am, I just issued a warrant for your arrest. Yeah, you come whenever you want to come. You don't come when you're required to come. I told you to be here at 8:30 today. You arrive at what time? Or, okay, 9. You came in? Do you see I have her check in? I know she's here now, but she got here when I looked over there, it was like 12. Right, You were set for trial yesterday. You appeared at 1 p.m. Just, you're not allowed to leave. We're trying to find your lawyer.
I'm trying to. Oh. This is everything said.
All right, guys, what'd you say about the,
We're
charge?
still going through it. It's
Yeah.
really long. It's really long.
Imagine a felony case. Like 80 pages.
I think my last one was 10.
Right.
In a felony case? That's short. Those capital cases, man.
Oh, no, yeah, that's a whole nother
It's a
ball.
book.
Not just a PCL.
Hey, Judge, I just talked to Josh and he said he would rather go over the plea papers with her in person.
Okay, so we'll roll it to tomorrow.
Okay, I'll let him know for tomorrow.
Call the warrant.
Yes, there was one more on page 35. Worrell. Jessica, set for arraignment, failed to appear first time.
2501. We need, her to sign a reset though, if you don't mind. If you don't mind coming out so we can have her sign a reset.
Yes, Judge, I'll come out in just a second. I have one
Yeah.
more to go over with you. Page 37, Zimmerman
Okay,
was set for arraignment yesterday. We rolled it for today. I did reach out to counsel multiple times via email and called and
no,
no
I didn't talk to her
response.
about this.
Yeah.
What do you want me to do? Did this person show up?
No, Judge, and you reinstated and gave him a week to get here.
Okay, 5002.
Okay.
All right.
Okay, I'm coming out.
Billings.
So John told me that the office.
Guys, you have an objection?
Yes, Judge.
Tell me.
The state's gonna object to the 3823 objection, Your Honor.
Okay.
And the basis for the objection is that I'm gonna say that we, the state and defense, are not in disagreement to the factual basis of the stop. John told me that on direct examination, the officer testified that he ran the defendant's registration and observed that it was expired. Defense did not contest that on cross-examination. So I'd argue that the state and defense are in agreement as to the basis of the stop.
I did contest it, Judge. I asked him, I said, what you perceived was speeding.
Tested both.
Right.
Yeah.
You perceived the speeding led you to running his plate, correct? Yes, I said, but if you hadn't perceived him as speeding, you would have not run his
I mean, he
plate, correct?
contested damn near everything. He did.
Okay.
Judge.
I'm gonna overrule your objection. I'm gonna allow it.
I understood the court's made its ruling. I would like to have that language reflected in the jury charge of those two areas for the basis of the traffic stop. The speeding and the expired registration, Your Honor.
Ray?
Judge, I think that the speeding, I think it's fruit of the poisonous tree. When you go into the, are we on the record? When you get into the, when you get into the speeding aspect of it, again, the officer testified that if he hadn't perceived him to be speeding, he would have never run his plate. So therefore, I think that just the speeding alone is sufficient to say he didn't have probable cause to do either one. Either he didn't have probable cause to.
So why do you have a problem if they put both? You know?
Because I believe it would be misleading to the jury, because I'm really contesting the reasoning behind it, the speeding. And then after he perceived the speeding, then is when he ran the plate. It's not that he pulls up next to him that he runs the plate. So I believe, but for the speeding, the plate would have never been run. And even the officer testified to that because I asked him, you were going the opposite direction, correct? So I think realistically, the biggest contested matter of fact is the speeding, which led to everything.
Okay.
So I believe a 3823 instruction with the speeding is appropriate.
And I do have a response, Judge.
Sure.
So yes, defense has mentioned that it's fruit of the poisonous tree. I don't see any indication of how getting behind a vehicle that he thinks is speeding is any sort of search or any sort of privacy interest that exists in that mere fact alone. While he was
contesting the stop.
He's contesting the stop. Yes, correct, Judge. And if I may, counsel. if there's two bases for the stop, then that should be reflected in the jury charge. It's
What's the 3823 just on the speeding?
just on the speeding.
Am I right?
That's correct.
Okay, so I'm gonna give you just that, what you're asking, for, right?
Judge, I believe the way it's currently reflected in the instruction would be misleading to the jury because it says, before you may consider the evidence obtained as a result of Officer Metter's stop and detention, you must all agree that the state has proven beyond all reasonable doubt that Officer Metter reasonably believed that the defendant was speeding before Officer Metter stopped him. The state's arguing that it's not that he has to show that he was speeding and that's why he stopped him. The state's arguing that that's misleading because he can get behind him even if he thinks he's speeding. And then if he happens to run the registration before he initiates the traffic stop, which he did in this case, and it was expired, that is sufficient for reasonable suspicion and probable cause to initiate the traffic stop on its face. The way this instruction is currently written, Judge, it's asking like, well, if he wasn't speeding, then you suppress all evidence.
That is correct, Judge.
I mean, I think, I agree with that too, you know, because they do, if he wants to run the plate just because it just wants to run it, he can do that. There's no law that prevents him from doing that.
Correct, Your Honor, and I can see that argument, which is why I specifically asked him, if you hadn't perceived my client to be speeding, would you have ever run his plate? And he said, well, I can run plates whenever. I said, in this particular instance, would you have ever run his plate? And I believe he said no. So if the court recalls on dash cam.
I understand it, I get it, I get it.
If my client had just
Still.
followed through the intersection, he would have, Officer Metter would have continued straight. He was gonna go straight.
How do we appease both of you in this situation?
Judge, let me tell you how this can happen. In the second paragraph on page 5 of the jury charge, it says you may consider this evidence, referring to the evidence that comes from.
Wait, where are you?
I'm on page 5 of the jury charge.
There's no evidence number, so.
Oh, sorry. It is under disregard evidence if unlawfully obtained. The second paragraph is just one sentence, Your Honor. You may consider this evidence only if you resolve a preliminary question in favor of the state. It then goes on to say that you need to address the issue of if they're speeding. That is going to inform the jury that they need to only consider the speeding and just disregard the other lawful basis of the stop.
You talking about the third paragraph?
The second.
No, it's where it says, before you consider evidence obtained as a result of Officer Micah Matter's stop, you must all agree that the state has proven beyond a reasonable doubt the officer reasonably believed that O'Dear was speeding before Micah Matter stopped him, right? So, but there are other ways, right? Because he used in his testimony 2 ways. He also said that I did both. You know, it's fair.
I can see that argument, Judge, but my position is still the same.
I get it.
Yeah.
So how do we put that in the language?
Judge, the easiest way to do that would be to say that, I'm looking at the bottom paragraph of that page, Your Honor. You must all agree that the state has proven beyond a reasonable doubt that Officer Micah Metter reasonably believed that the defendant was speeding or had expired registration.
Right?
I would still object for the same reason, Judge. I believe that the order expired registration is.
Okay,
for the
I guess I'm gonna overrule your objection because we'll just put or registration, you know? I mean, unless you have a better wording for it.
And or?
And or. Are you happy with that? Yeah, because it's and or. It could be both. Yes. Are you happy with that?
That's fine.
Okay, done. So just put and or, and then after that, no objections from the state?
I saw, no, never mind.
Just a moment, Judge. I haven't read the last page here of the jury charge.
Is there another issue?
I don't think it's a huge problem, but if the state wants to address it, I have no problem fixing it.
I agree with defense, Judge. I don't see it's much of an issue. It's just that on the page.
On the definition of intoxication, Judge.
What about it?
I think, I would like to.
Okay.
Yeah.
Yeah. We would just like to clarify that to number it as 1, 2, and 3, 1 being not having the normal use of mental faculties, 2 being not having the normal
Yeah,
use of
no,
physical.
that's right. It's gotta be 1, 2, and 3. Right. Yeah. That's okay.
All right.
Yeah, I have no issues with that, Judge.
Okay. So we'll fix those and then no objection, we get them in here. Yeah, all right.
No objections, Judge.
All right, for the jury.
All right, please be seated. Okay, filet and lobster good? Okay, members of the jury. The defendant, Odir Alberto Gamez Santamaria, stands charged by information with the offense of driving while intoxicated in Harris County on or about October 6, 2024. To this charge, the defendant has pleaded not guilty. Both sides will soon present final arguments. Before they do, I now give you the instructions you must follow in deciding whether the defendant has been proven guilty or not. You will receive a written copy of these instructions to take with you and to use during your deliberations. I've now signed the verdict sheet. Each side will get 20 minutes for closing. State.
Thank you, Your Honor. The state waives its opening and reserves time for closing evidence.
Okay. Defense, you may start.
May I proceed, Your Honor?
Please.
I told you at the beginning of this case, in my opening, of the things you would not hear. I told you would not hear what his exact speed was. And I told you would not hear what his blood alcohol content was at the time he was driving. Out of all 4 witnesses that the state has put on, not a single one of them could say that with absolute certainty. Nobody can tell you either one of those facts. You heard from the analyst who said that he would need specific facts to determine what his alcohol level was at the time. He talked about absorption, how alcohol enters the body, how it takes some time for the alcohol to enter the body. And when asked, can you do that in this case? I believe the state asked him that. He couldn't. So we don't know what his blood alcohol content was at the time of driving. We know what they claim it was, or what the sheet shows it was at the time that he blew. That doesn't mean that's what it was when he was driving, right? Then he talked about the mental faculties and physical faculties. And the analyst told you that he believes somebody with a 0.08 loses all faculties, right? And I asked him, does that include driving? He said, yes, I believe it includes driving. I said, would you expect to see other driving patterns? Would you expect to see swerving? Yes. Would you expect to see an accident? Yes. None of that happened here. It was supposedly speeding was the only issue, right? Now let's talk about the speeding. Officer Metter driving northbound on South Chestnut. He says he knows that intersection well because the station is not far from there. And he knows how fast somebody's going because of the flow of traffic that goes from there. There was not a single car on that road, not one. He admitted it. My client had the green light. He didn't run a red light. In fact, we see him stop at the appropriate place at the next intersection. So it doesn't run a red light. There's no traffic to compare his speed to. Metter waits 10 seconds before even pulling out, or 8 seconds before even pulling out and go after him. And then when he does go after him, he claims he hit 64. He says that you can see that on the video. We didn't see that on the video. There's nowhere on that video that doesn't show what his speed was. Why? Because we don't know what his speed was. That's just what he said it was, right? The evidence speaks for itself, ladies and gentlemen. Evidence speaks for itself. So then he says it's about a quarter mile to the next stop. So if he's doing 65, and my client's doing 65, he even admitted to you, Metter admitted to you, that my client would have been long through that next light before Officer Metter even hit it at a quarter mile. He was not doing 65, ladies and gentlemen. In fact, we don't know how fast he was going. Why don't we know how fast he was going? Because Metter didn't try to put a radar on him. He didn't try to do anything except pull out and say, I'm gonna go stop this guy. And then when he gets up there, here's where the state wants you to say, oh, this is the problem. This is the reasonable cause or probable cause for the stop. He runs his plate and finds out the registration was expired. Okay, I asked Metter specifically, is expired registration indicative of intoxicated driving? Of course not, right? It's a fix-it ticket. That's what you get. You gotta get registration, pay the ticket, case gets dismissed. So, and I asked him, but for the fact that you perceive my client to be speeding, would you ever run his plate? He said no. Why? Because he was going the opposite direction. He was going northbound, client was going eastbound. Westbound. Had to do the never eat soggy Wheaties. Yeah. So client was going westbound. Complete opposite direction. So, but for Metter thinking that he was speeding, he would never pull up behind him. If he never pulled up behind him, he would never run his plates. He never run his plates. He would never have seen the registration was expired, and therefore my client would never have been pulled over. Let's talk about the investigation itself. When he pulls into the gas station, Metter realizes Mr. Gomez doesn't speak English very well, so he calls for a Spanish-speaking officer. Ruiz shows up. Ruiz starts talking to him. And Ruiz told you that he didn't translate everything verbatim. He paraphrased it, is how he put it. Metter testified that there were inconsistencies in my client's statement, which led him to believe that he maybe didn't have the mental use of his faculties due to intoxication, right? But there were no inconsistencies. You heard Ruiz talk about coming out from Cleveland, helping the client move. Ruiz didn't translate that all. All he said was he came from Cleveland and he helped a friend, right? Then later on, he says again, he helped a friend move. And then Ruiz says that. And then Metter tells you, well, that's an inconsistent statement. He told you he came down to get gas. He was coming from his house to go get gas because gas is cheaper on the side of town, right? That's what the client said, right? And Ruiz said that. Officer Metter says, oh no, that's an inconsistent statement. He never said anything about getting gas before. He said he had come down, helped a friend move. He said that the first time, he said it the second time. And then they asked him, well, where is he going? He said, he was coming down here to get gas because it's cheaper, right? So he came to get gas because it's cheaper in that thing. Then Metter goes on to talk about, oh, I pass all these gas stations. Well, we all know there's gas stations everywhere. Every single gas station has a different price. I know I've got my favorite one I always go to, and I will pass a dozen other stations to get to that one to get the cheapest price on gas, especially nowadays, and especially coming into the summer months. We all know that. So everything that Metter told you or used in the totality of circumstances is perfectly reasonable. Now let's talk about the field sobriety tests. They want you to start right here, like this, right? I'm struggling to do that, and I have perfectly good balance. You start here, and then you've got to do heel to toe for 9 steps, and then a series of small turns. I know the SFSTs inside and out. I was a prosecutor, I was a police officer, a prosecutor, and now a defense attorney. I've done these thousands of times. I've seen them thousands of times. All right? So I can do them. My client got 1 time on the instructions. Metter claims he took 8 steps instead of 9. Okay, maybe he miscounted. Right? And then a series of small turns. They expect somebody to do this to turn around. Right? That's not a natural movement. Everybody, when you turn around, when you're just thinking, I gotta turn around and go back, you get to the end, you turn around and you go back. No falling over, no stumbling, nothing. Just an unreasonable test that is perfectly unnatural for a human body to perform. And he claims that the National Highway Safety and Transportation Committee established these so that would be difficult. Sure, maybe that's the case. But even a sober person, I believe he even said, somebody, what were his exact words? It was relatively easy for somebody who is not intoxicated. Not completely easy, not perfectly easy, not easy at all. Right? Relatively easy for somebody who's not intoxicated. So the field sobriety test, useless. Absolutely useless. And then he talked about, him and Ruiz both said, with a strong odor of alcohol on his breath. Right? But then I asked, if you have one, maybe 2 beers and have a strong odor of alcohol on your breath. Yes. I asked later, if you have 2 beers, are you intoxicated? No. And then we get to Varner, and Varner says it was a moderate to mild odor of alcohol on his breath. Which one's the truth? We don't know. We weren't there. But that's completely unreliable as well, because there's inconsistent statements. If Better wants to use the inconsistent statements, that's an inconsistent statement amongst the state. These are the people that work for the prosecutors. This is their job. Their job is to find people guilty, for the state, not the prosecution. Their job is to look for things to find people guilty. Right? That's what they try to do. So they're going to say what they want to say to get to that point. Now, as far as the jury instruction, there's a section in the jury instructions that says you are to disregard evidence if unlawfully obtained. Page, I believe it's 5. 1, 2, 3, 4, 5. Page 5. An entire section talks about evidence unlawfully obtained. I've already explained this to you, but I'm going to go over it again. The matter says he knows that intersection. Based on the flow of traffic, he believed my client was speeding. There wasn't traffic. He couldn't go after him. He couldn't tell how fast he was going. Then he goes out after him. A quarter mile later, he catches up to him and runs his plate. That is, without him thinking that my client was speeding, he would never run that plate. That's unlawfully obtained evidence. He just looked for something to find.
Objection, Your Honor. May we approach?
Why just lose it? I said, like for him going after me. Or so. Okay, at the end of it. Right, and so. So you can as well. All right, come on. 3 minutes.
So, again, speeding goes in behind, runs plate. That tells you here down at the bottom, and or expired registration, right? What I'm asking you to think of is, why did he find out that registration is expired? What led him to that? But for him perceiving a speeding, he would have never run that plate. And if you find that probable cause did not exist, or as well as you don't believe that he lost his mental faculties, we didn't see him fumbling, we didn't see him walk, urinating himself, we didn't see him everything during jury selection. I think somebody said that. You know, they urinate themselves, right? They stumble, they act a fool, they're belligerent, things like that. We didn't see any of that. What we saw were those unnatural field sobriety tests that are designed for people to fail. That's what we saw. Nothing else. No other driving facts. So no loss of mental faculties, no loss of physical faculties. And then they say at the time that he blew, his alcohol was 0.153, but nobody can tell you what it was at the time he was driving. The law is driving while intoxicated, not intoxicated when you blow into the machine. Driving while intoxicated, which means they have to prove beyond a reasonable doubt that at the time he was driving, he either lost his mental faculties, lost his physical faculties, or was it 0.08 or higher. They have proven absolutely none of that. So ladies and gentlemen, the jury, you have one verdict and one verdict only. It's at the very top right there for you. We, the jury, find the defendant, Pudier Alberto Gana Santa Maria, not guilty. Thank you very much for your time.
Okay, thank you. All right, State.
Thank you, Judge. Judge, may I publish a PowerPoint for the jury? May I publish a PowerPoint for the jury?
Sure.
All right. Defense said a lot of things. Some of it confusing. Some of it, right? Let's start with the jury instructions. This piece he pointed out to you said disregard evidence if unlawfully obtained. There's a piece I want to circle here. It does not say that you must all agree the state has proven beyond a reasonable doubt that Officer Metter reasonably believed that the defendant was speeding. It says was speeding and or had expired registration. Ladies and gentlemen, this isn't hard. The officer thought he was speeding. He goes to the light, the officer sees him, he follows him, he tracks him, he pays him. Was it perfect? No. But he gets up to the light and he runs his registration. He finds that his registration is expired. That's all he needs. That's it, right there. That's what the jury instruction says. It says or. If you find that he had expired registration, it doesn't matter. Look at all the evidence. Now, let's go through this and let's make it easy. That's all pretty quick. Every single person, except for the last witness, said that this occurred on October 6, 2024. That's an easy one. Let's cross that one off. The officers both said it was in Harris County, Texas, and in a public place. We know that it was this defendant. How do we know that? Because the officer said it was. Because the officer said, I was going down the road, I saw this car, I pulled him over, and he was the one behind the wheel, and you see him on the video. Let's cross off another one. Operated in a motor vehicle. How do we know that? You saw it on the video. The officer told you everything you need to know. It's not hard. In a public place. You see on the video, he's at a gas station. The officer tells you he's at a gas station and he's operating the vehicle on a public roadway. Straight from the officer. It's not hard. None of those are hard. And barely useful. Then we get to while intoxicated. This is still easy. Why is it easy? How do we know he was intoxicated? Because I have this piece of paper that says subject name, that has the operator that you heard from, his signature on it. And it says what his DNC was when he blew. Now, this is important. What does it say? Let's use the low one, 0.153. This is a smaller detail that you may not have caught, but you have to use your memory, think back. When the officer was telling you about the HGN, you remember there was a small part at the end of the HGN where he said, onset, he was talking about the onset prior to 45. And it's what the officers used to calculate about where the defendant is on the scale. He told you what he thought the defendant was at that point in time was what? It was around 0.15. And then he went and got a breath test and he confirmed it. That's all it is. It doesn't have to be hard evidence. Remember yesterday we were talking during jury selection, and I brought up Stonehenge, and I said, and I told you, you might not have the full picture. But you didn't need the full picture. When you get enough pieces together in a puzzle, you know what the picture is. And that's all this is here. We have all the pieces we need. Only thing left for you to do. So go back in the jury room, pick a format, and return your guilty verdict. That's what I'm asking you to do right now.
All right, thank you. All right, ladies and gentlemen of the jury, it's now time for you to deliberate. Get you going, do you mind escorting them to the jury room? Okay, all right, so, good luck. Okay, we're in recess. Question?
Yes.
Verdict.
I'm assuming it was one.
Think it's a question?
Yeah, one question.
Yeah, but they always hit just one. They never did two.
Oh. You got a question? Question?
Or we heard a ding. I don't know.
Hey, you guys.
Verdict. Hey, we have a verdict. Ramona. Let me go get Ramona.
Yes. Because we always need those before they leave. Do we need it? It just in case it's. No, but I think we can just stipulate on, right? No, we need to look at the signature and the judge's signature and everything. For the jury judgment. Oh, that part.
Yeah, let me get him in first to sit.
Yeah, yeah. Okay. I thought you were talking about first one. No.
Okay, you ready? Okay.
Yeah.
Oh, where's Tony?
No. Oh, wait, we need it.
Yeah, he went to go get him.
All right, for the jury.
Okay. Ladies and gentlemen of the jury, have you reached a verdict? Is it unanimous? Okay. I'm now going to read to you in the state of Texas, cause number 2532700, the state of Texas versus Odir Alberto Gamez Santa Maria. We, the jury, find the defendant guilty of Class A driving while intoxicated as charged in the information. Okay, you've been found guilty. You may take a seat for a moment. Does anybody who would like the jury polled?
Yes, Your Honor.
Okay. Ladies and gentlemen of the jury, is this your verdict, man? Is this your verdict?
Yeah.
Is this your verdict? Is this your verdict? Your verdict?
Yes.
Your verdict, okay.
Thank you.
All right, sir. Just give me a second. Ladies and gentlemen of the jury, you have concluded your service. I thank you for everything that you've done. It's really an invaluable service. You may now retire to the jury room. If you give me a couple minutes, I'll come back there and talk to you, and then we'll try to get you all the things that you may need to get you out of here. Thank you.
All right, for the jury.
Please be seated. Mr. Gomez, I want you to understand that you do have the right to appeal this verdict. If you decide to do that, there are certain timing requirements that must be fulfilled and documents filed. I can let your attorney explain as much as he knows, if that's something that you want to do, but timing is of the essence if you want to appeal this, but you do have that right. We do have to sentence, and if I'm correct, parties, you have agreed to a sentence.
Yes, Your Honor.
Okay, and the agreement is?
210 days.
With credit for the 73 days. Okay. I'm now going to sentence you to 200 days in jail. I will give you credit for 73 days that you have done. Mr. Gomez, you need to understand that this will now reflect as a conviction on your record. This now makes 2. If you ever pick up another DWI, you will be charged with a felony offense, and you will be looking at a minimum of 2 years in prison, a maximum of 10 years in prison. I would never, even if you've had a sip of alcohol, get into a car and drive because you are taking a huge risk. Do you understand? Okay, so you may be seated, and I think that.
Are we gonna keep it as a second with the Class A?
Yeah.
1.5?
Yeah.
So you're making sure, okay.
Yes. Well, they found it. Yes.
No, they found the .152. The second is an punishment enhancement, which would need to be found true as well.
Guilty.
Yes, we'll stipulate to the first.
Okay.
Doesn't really change anything.
Right, okay, so we need him to sign documents, so just don't send them down until the documents are ready to be signed. I'm gonna suspend the license for a year, okay? Do not drive until you get a license. Otherwise, you'll be right back in custody.
Just for the record, Judge, although I've admonished him, the court admonished him that this could have negative effects on his immigration status.
Right, okay, yes, that's in fact true, right. You being found guilty of this DWI offense, this can and probably will impact any kind of immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You have an ICE hold now, so you know now that there are immigration consequences for future purposes. When you're on bond, don't violate, there are severe consequences, as you now know. Anything else you'd like? State? No fines. Yeah, no fines, nothing else, just, I'll waive any kind of surcharges that will be imposed by the Department of Public Safety. Right, so if you don't mind, give me the motion and then I'll sign it for you.
Thank you, Your Honor.
Okay, all right, so just hang tight, but don't send them down just yet. Okay. All right, let me go talk to them real quick and then I'll let you guys go talk to them as well. But we are done.